Information Technology. Also inviting eminent speakers, Mr. Grant Philpott, CEO ICT EPO. Inviting Dr. Viswanathan Seshan, IP&S Manager Healthcare Philips. Inviting Mr. V. Lakshmikumaran, Founder and Managing Director of the Lakshmikumaran Sridharan LNS. Mr. Ganapathy Narayanan, Lead IP Governance, Tata Consultancy Services, and Mr. Daniel Lee, Journal IP Council, Southeast Asia, INKR IP Intellectual Property, Continental Corporation. May I once again invite Mr. Grant Philpott and Mr. Daniel Lee to join us on the panel. Ladies and gentlemen, please put your hands together to welcome our distinguished panel on the stage for the panel discussion session. May I once again request for all mobile phones to be put on to silent mode, the exit doors to be closed, please. Namaskar and good morning, and a very warm welcome once again to this panel discussion session, which is the first session of this conference. The topic for this session is the role of IPRs in emerging technologies, IoT, cloud, big data, analytics, and blockchain, etc. Ladies and gentlemen, our two distinguished chairs for this session, Mr. Raimund Lutz and Vice President EPO, and Dr. Debashis Dutta, Group Coordinator R&D Electronics, the Ministry of Electronics and Information Technology, would be chairing this session jointly. We have our 5 eminent speakers on the desk, and the time duration for this session is approximately 1 hour 15 minutes. You can have question and answers in the end after the deliberations by all our eminent speakers. With those words, I hand over to the distinguished chairs, Mr. Raimund Lutz and Dr. Debashis Dutta. Over to you, sirs.
We are initiating the first session of this afternoon. Basically, role of IPR in emerging technologies, and some of the technologies you have heard in the inaugural speech from various speakers on IoT, cloud, big data, blockchain, etc. I would also welcome at this stage co-chair Raimund Lutz from EPO. And before I introduce the speaker's profile, I would like him to speak a few words. I think we can do it from there. Yes, yeah, I'll waste time with this.
Yeah, thank you, Mr. Dutta. It's a great pleasure for me to co-chair together with you this discussion round. Well, ICT Industry 4.0 is a new world, and we have to see how it fits into the, let's say, old world of the patent system. And the big question is, well, is the patent system, the existing patent system, ready to serve also the new world, let's say, in ICT, artificial intelligence, Internet of Things, cloud computing, all these questions are around. And this discussion round today should enlighten us a little bit and should tell us what we can expect from the patent system. I think we can expect a lot already on the existing rules and regulations, but we have a number of excellent experts here around this table which can enlighten us even more. So I forward you the floor to introduce all our experts.
Right.
Mr. Dutta.
At this stage, I would like to introduce the speakers of this session. Mr. Grant Philpott. Mr. Grant Philpott is Chief Operating Officer's ICT EPO. Mr. Philpott has been Principal Director in Search and Examination area of EPO since 2012. In 2014, he brought together the EPO computer and telecommunication patenting operations and now manages the resultant information and communication technology. During his 26 years at EPO, he has worked across a broad range of technical field, including mechanical, industrial chemistry, and other subjects. Let me, Mr. Philpott. The next speaker in the panel would be Dr. Viswanathan Seshan. He is Manager Healthcare Philips. Mr. Viswanathan Seshan holds the position of IP&S and manages Philips International Property and Standards. He manages a team of IP counsels that handles global IP of various business such as monitoring and analysis, therapeutic care, digital pathology solutions. The activities he oversees include IP portfolio management, business counseling on various types of segments and contracts. Mr. Viswanathan. Our next speaker on the panel would be Mr. Daniel Lee. He is General IP Counsel, South Asian Continental Corporation. Mr. Lee has been with this organization and also an attorney in the European Patenting Office in 2015. He also served the Patent Council and Continental in Frankfurt, focusing on safety, telematics, and communication. In 2012, he chaired the German patent attorney examination. Mr. Lee holds a degree in mechanical engineering. Mr. Lee. Mr. Lakshmikumaran, the founder and managing partner of Lakshmikumaran and Associates. He is the founder and is well known in India and internationally. He established the firm in the year 1985, and ever since he has been supporting and helping a lot of startups as well as established company from within India. Further, he has been in the Supreme Court and also the High Court, supporting various clients in his capacity. Mr. Lakshmikumaran. Mr. Ganapathy Narayanan, he is Tata Consultancy, well known in his field. He is currently responsible for designing and conceptualizing implementation of the governance of IP engineering industries at Tata Consultancy Service. Mr. Narayan holds a graduate degree in electrical engineering, specializing in computers and control engineering. In his career spanning over 34 years, he has worked in various multinationals and Tata Group companies in the development and management of wide spectrum of technologies. Mr. Ganapathy. So I think I will give you the prerogative of choosing the speaker to start with.
Yeah. It's difficult to do this job, I think. We can count. I think it's we should not lose time, and we should give the floor to our experts. Perhaps I start on the left side, if I may.
Sure.
Mr. Lee, if you could provide us with your experiences in patenting in the field of new technologies.
Yes, sure.
Please, you have the floor.
So, thank you very much for having me here in this round. And let me first shortly introduce Continental. Most of the people I meet when I talk about Continental, they recognize us just as a purely tire-bound company. Of course, our orange colored brand with the horse that you see on the side of any football pitches or international games, where we advertise our tires. But actually, Continental is more than just tires. Tire business or rubber business in Continental is 1/3 of our revenue, and 2/3 of our revenue comes from automobile supplier parts. And in total, last year, our revenue has been over 40 billion euros. So it's a quite huge automobile supply company. Depending on the statistics, some people say Continental is number one, other people say Bosch is number one. But anyway, we are one of the biggest automobile supply companies, and thus it is the topics of IoT, AI, big data, and cloud is becoming more and more important for us. Why is that so? Of course, the most obvious reason is cars are becoming more connected and cars are becoming more autonomous. That is, the business in our domain changes from a purely, let's say, hardware-driven business to a more service-driven business. It is visible that our business will not continue as it is today. In the past, the business was quite OEM centric. So we had our customers, they requested to develop certain ECUs or automobile parts like a cluster, heat controller, steering, brakes, etc. So you develop them, you put an ECU with a low-level software on them. The functionality, the scope of this product were quite well defined. Whereas nowadays, you can't just stay with this business anymore, because it is eminent that this business will not create enough revenue. The big revenue which we foresee will be in the domain of services. And when it comes to services, this is actually where we face, let's say, the biggest challenges to also in the IP field, because when you come to patents, come from a world which is very well bound to hardware and or isolated products. It is very easy to protect a product, a certain feature of a product, and to get a monopoly on that. It is also very easy to distribute, to sell these products on different countries. So you have your very well-defined markets and defined customers. So it is easy to select these countries and go there and protect your innovations and inventions. Whereas when it comes to services, you suddenly realize that the fundamental conditions and framework of those services are different than from products. You are not dealing with you're not developing those services all by yourself. You always have partners, so you have to deal with third parties. Secondly, then that is actually one of the bigger issues. Services are evolving over time. Services are evolving very rapidly. Services are evolving depending on the demands of your customers, which lasts maybe for 2-3 years, and then a new trend comes, and then you have to adjust your services. So you can't just have the same old time modeling, like that you develop a product over 3 years, you bring it on the market, sell it for 7 years, and then over the 10 years term, you have a protection by your patents. You have a certain continuous involvement which you have to cover somehow by the IP system. And furthermore, services are also not bound, restricted to certain countries. Services they do not mind if you can provide a certain part of a service in one country and the other part of the service in another country. So how do you protect this? So all this together, all these 3 points together, brings us to a huge challenge. How we want to protect our services in the future. So, having said that, of course, I think it is clear that we won't find this solution like from today to tomorrow. But what we realize is that first of all, you have to increase the awareness that although you have all these challenges to protect services, you have to increase the awareness within your organization that it is worth thinking about how you can protect the services, how you can modularize the services to protect them, and also how you can more organize your company flexibly, that the decision time, processing time internally gets faster than at the end than it was before. And also, I think one thing we also want to highlight also to the patent organizations is how beyond the existing claim categories of apparatus methods, what else can we do actually to protect services? We should really think about how we can protect services beyond methods, and how we can protect software beyond just of computer implemented methods. And I think overall, yes, it is a huge challenge we have, but we see that through increasing the awareness and through looking in every detail of our business, that we are able to provide individual solutions. But of course, over long term, it would be really desirable that working together with the governmental organizations, how patents can be applied cross borders and also broadened in a sense to protect services and software in a better way. Yeah, thank you.
Yeah, thank you very much, Mr. Lee. We will come back at the end of this first round to your questions and expectations. So I will continue with another representative from industry, with Mr. Narayanan, who is representing Tata. And then the next one will be also the industry representative. And later on we come to the lawyers and, and to the experts in ICT patents. So, if you agree, Mr. Narayan, you have the floor.
Thank you, and thank you for having me here as well. When we look at the topic of and the importance of IPR and the new age technologies, I would look at the impact from 3 dimensions. First, the business dimension. As the technology evolves, more and more investments are needed to mature the technology and make sure that these technologies go back to the society for enrichment of the society and benefit to the society. And unless there is a mechanism to have appropriate rights given in these new age technologies and new IP that is being developed, the investments will also be limited. So definitely, yes, from a business perspective, it's very important to have IP rights on the newer technologies. But it's easier said than done, because the new age technologies are different from the traditional technologies that were being developed earlier over several centuries, where it was a very pinpointer or a narrow set of technologies that were being developed, and then those technologies were going to the society for the benefit of the society as an isolated technology. But what's happening now with IoT and cloud and big data and all these and AI and all these technologies, they are not separate. when they go to the society, these have a very high level of interaction, a lot of synergy. Okay, so the investment needs to be made across multiple technologies. The right services that can be built over these technologies for the benefit of the society needs to be identified and appropriately protected, with a balance between protection of these IPs and the benefit to the society. That again is a challenge, because any of these IP, any business is sustainable only when the society benefits from that technology. If the society does not benefit from the technology, all these rights are not sustainable. One. Two, the second dimension I would say is the technology dimension. When I talk about the technology dimension, there are a few things involved, because these new age technologies are across multiple areas. Interaction between these areas is a challenge. So standards have to evolve so that all these technologies talk to each other seamlessly. Okay. So standard becomes important. When you talk about standards, then obviously standard essential patents as one of the forms of protection of the IP here becomes important. To, of course, investing in multiple technologies simultaneously, or collaboration between various entities who develop all these technologies and bring them together. That's going to be another challenge. And one more thing that is often ignored initially, then has a great impact, is that these days the technologies are not used as is. In the early days, when inventions were happening, there were isolated inventions which could be taken to the society, taken to the market directly and then used as is. But now, every technology that you use, whether it's an IoT, big data, artificial intelligence, around these inventions in these areas, one needs a service to be built around this. So there is a very high percentage of service element when these are taken to the market. So these services also have evolved over several decades, where there have been innovation in services, IP in services. So how does one protect the IP in the services? That's another thing that we need to look at. The third dimension is the policy and administration. Are the current policy, IP policies across the globe, sufficient to protect, to offer a form of protection to these new technologies and the services? If they are, do we need to relook at them? Is there a uniform way of interpreting these policies against, for these new technologies across various patent offices, or even within a patent office across various examiners? Is it really possible for one or various examiners to interpret uniformly any invention that comes in these areas which straddle across multiple technologies like IoT or artificial intelligence? It's a big challenge. Okay. So when we start coming out with the guidelines, are we really going to provide a uniformity in this? That's something that needs to look into. Probably what is needed is in each of these patent offices a cross-technology team of examiners to need to be formulated to look at these new technologies. These are some of the initial thoughts that come to me as the dimensions that impact the new age technologies when it comes to IP. Thank you.
Thank you very much for this and for these also interesting questions you have raised. I hope we can answer these questions later on. So, Mrs. Seshan from Philips, you have the floor as the next
Thank
speaker.
you.
Please.
Thank you, Mr. Lutz. I guess I'm the only representative of the healthcare industry in this panel. So, for the time being, I guess you'll have to take my word for what I say. Having said that, I promise to tell the truth. It's an honor to be here, really a privilege to be sharing this days with such accomplished speakers. And actually, it's even more of a privilege to see some of the people that I respect, that I really have learned from, to know that you're sitting in the audience waiting to listen to us. Thank you very much. Thank you also for to the organizers for having us here. And actually I don't know which of the chairs decided that we shouldn't have a presentation, but thank you for that as well. Philips, the word Philips usually brings to mind the light bulb, but I guess most of you may know by now that Philips is out of the lighting business. Last year, our chief innovation and strategy officer declared that Philips has now become a 100% health care or health tech company. Philips comprises three main divisions. One is the diagnostic imaging, which I think all of you may know. We make the MRI, the CT, the ultrasound, all those diagnostic images that when you go to a doctor, they see inside your body. We make patient monitors, which is a connected care group, and we also make consumer lifestyle products. What I'm going to talk about today a little bit is about the importance that we place on artificial intelligence and the role it plays across all these products. There was a time when Philips used to focus on selling boxes and decided that the rest was, well, somebody else's game or secondary in nature. But that has changed very rapidly and is actually, the pace of change is actually increasing even as we speak. So if you take an MR system, which is where I did most of my studies when I was, younger, most of it was just a few acquisition codes that you wrote to collect some data and so on and so forth, and nothing much happened after that. You looked at it would go to the radiologist, radiologist would look at the images and say, I think this is a lesion, I think that is okay, and so on and so forth. Today you have systems, and by the way, what would happen, and I'm just giving you examples of where AI can help. If, for instance, and an MR scan can take anywhere from 10, 15 minutes to an hour and a half, maybe more. After all of this, the patient is wheeled out, and then the doctor says, oh, you didn't catch this just right. I think we need to have another scan. And there goes all the prep, all the time that you've spent. With AI, it's it is actually possible to actually do all this analysis in real time. Get the patient into the into the MR system, get the image, look at the data, and say, wait a minute, this is not exactly what I want. And that's not the doctor saying, that's the AI saying it, and saying, this is not what I want. Can you take another scan? Or even, for that matter, automating the scan, adjusting the parameters, and then taking the scan to get an image of the right quality, of the right place, etc., etc. This you can extend to MR or anything, ultrasound, for instance. Ultrasound particularly is interesting because if you look at ultrasound, there is a heavy dependence on the operator. I don't know how many of you have gone for an ultrasound system or watched an ultrasound scan, but it's actually a probe that the doctor or the technician operates. And a lot of times, that skill is developed over a long period of time. Without AI, it's often a trial and error until the doctor or the nurse learns enough that that they can actually pinpoint something very, very easily. AI can help with that because it can guide and it can detect, it can guide, it can compare, and it can say, move left, move right, or even, for that matter, if you can attach it to a robotic arm, give you the right image without human intervention. But at no point in time do I want to imply, if there are doctors in the room especially, that we, as healthcare companies, aim to replace doctors and nurses. That's not going to be possible. This is an aid in order to take away mundane tasks. So, for instance, another example of that would be reporting. If you have a report that is being provided, the report has to be actionable. And reporting is an enormously time-consuming procedure. AI can actually automate that for you. And if you do that well enough, then the doctor or the nurse is now free to actually focus on the most important thing for them, which is the patient, rather than talking about reporting and all of that, which are all distractions. Go to an ICU, and now I go to patient monitoring. If you take an ICU, which is an intensive care unit, if you sit there for half an hour, you will go crazy. Simply because, not because of the, people are sick and lying there, but simply because of the number of alarms that you hear. There are beeps and clicks and all kinds of noises that keep happening all the time, to the extent that the nurse or the doctor believes that unless there is a louder alarm, I'm not going to listen to it anymore. Right? Now, of course, we cannot stop the alarms, but maybe we can prioritize them. Who does that? AI again. Look at all the vital signs of patients, look at, see what is happening, give a contextual basis, look at the history, see if they have, had relapse earlier, etc. And AI can then help point out to the nurse, of all the alarms that you see, go to bed number 34 because that patient is going to be in problem in the next few minutes. And that is the other advantage of AI. It is proactive. A nurse or a doctor hears the alarm, by which time it's actually too late because the patient has already relapsed. AI can look at the history and the progress and say, in the next couple of minutes, few minutes, this patient could go into maybe not cardiac arrest, but maybe respiratory distress. And then the doctor or the nurse can be directed to that. Hospital to home or home at the ICU at home. These are all new concepts. In the future, we believe that hospitals, the importance of hospitals will not be in treating the sick. Hospitals will focus more on keeping people healthy at home, because getting a patient into a hospital is very expensive, and getting them out just so, and without proper treatment or without follow-up, then they come back again, is even more expensive. We all know that there are, we know the population of the world, and we know that there are not enough doctors to take care of all these people. That's where AI comes into play. By the way, I'm sorry, if I'm going over time, please tell me, I can talk a lot.
It's okay.
Okay. So, when you look at all of these, AI will play a big role, especially take countries like India, where you go, most doctors that I know, and I know quite a few of them, would prefer to stay in big cities, and I don't blame them. If I were a doctor, I would do the same, right? How many of us would want to go to a really, really, really remote area and treat patients? There are a few, and those are noble souls, and I accept that, and I applaud them. But the fact is, majority of us are not of that type of, not of that psyche, and therefore, we would like to have, say, an AI system that alerts us, that can communicate with, so you have a remote system that connects to a doctor in, say, Bangalore, Delhi, wherever it is, and then you can guide them, you can guide the local people, locally trained people, to do reasonably complicated maneuvers. I'm not talking of surgery, but maybe some interventions, injections, and so on and so forth. And the third group that Philips has is called Health and Wellness Group, which, and this is also quite an interesting group because it's got things like parental guidance for babies. It's got kitchen appliances, garment care, personal grooming, and you might wonder how all of this is connected to health. Well, it certainly is in a way, in the sense that what you eat is what you become, right? So if we can guide you to eat right, then hopefully you will turn out right. No, I'm sure you will turn out right anyway. But the fact is, we can help. We can check your nutrition. We can check your, at some level, maybe at some point in the future, we can even probably look at your, history of disease, of your DNA, of your genomic makeup, and say what foods can cause or have the potential to cause or trigger a cancer in your particular body. Because each of us is different. Eating carrots is not guaranteed to eliminate cancer for everyone, right? It could be potatoes for somebody and tomatoes for somebody else. But how do we determine that? And of course, I'm oversimplifying it a little bit, but the point is, each of us has a genetic makeup that is unique, and the triggers that can cause certain diseases in our body, each of us has a unique trigger. Can we identify that in the future? Maybe a few hundred years from now we could, but these are baby steps that we're taking by creating a genomic map, making sure that we can tailor medicines to treat you and your disease uniquely. And that is where AI will help. If you take personal grooming and oral health care, you might have heard that bacterial diseases of the mouth actually have a very, very deep and significant effect on your health of your heart. And now there are technologies that can help in identifying if you've cleaned your teeth properly. Getting infants to clean to brush their teeth is a chore, is a real headache. But with new technologies that can interface with them and interact with them and tell them brush here, brush right, and then rewarding them with a song or a dance or whatever it is on the screen, helps them, turns this into a game. And in a way, it is artificial intelligence. So having said all of this, the one thing that I think cuts across all of this is not just the IP part, but the data part. Everything, all that I've said depends on the data that is collected and the data that is being collected over every day, every minute. Petabytes of data is being collected every year. So I will not talk about the storage and all of that, and the access, which is where the cloud is. For us, the most important point is about the data policy that we have. what about the IP in that data? Who owns it? How do you share that data? What about the liabilities that come out of this? What happens if an advice that is given doesn't prove to be right, and will the company be liable? To what extent? Who indemnifies whom? Especially when you take artificial intelligence, there could be one guy that makes it, or one company that makes it, one company that uses it, another company that maybe leases it. And let's say that this artificial intelligence creates an idea and somebody files a patent on it. Who owns that patent? Is it the company that made the AI? Is it the company that leased it? Is it the company that bought it? Is it the company that used it? And then you're going to get into infringement. Let's say that somebody infringes the IP that is created by this AI. Who do you hold liable? Right? And I see lawyers in the room, some of them with me, and maybe they can help answer that and shape the policy that will give us legal certainty in the future on how these issues will be handled. But for the time being, what we within Philips do is we handle IP in AI mostly as software inventions, because that's what they are. And the deeper we go, so for instance, there's AI, there's machine learning, there's deep learning, and the deeper we go, the more we tend to see if it is detectable, and if it is not, maybe it's good to keep it silent, maybe a trade secret if it really gives you an advantage. But that doesn't mean that you shouldn't file patents, explore possibilities to patent these, especially the ones that are detectable. Definitely look at copyright protection, design protection for user interfaces, and so on and so forth. So for now, the policy, as far as IP strategy goes, I don't think our IP strategy has changed dramatically, but we do focus a lot on algorithms, software protection, and data. Thank you.
Thank you very much, Mr. Seshan, for this very, very deep look into the applications of artificial intelligence in the future, and
My pleasure.
with some questions with respect to IPR. So let's now continue with the lawyers and their view on the role of IPRs in the emerging technologies. Mr. Lakshmikumaran, you have the floor.
Thank you. Whenever I hear about artificial intelligence, big data, iCloud, etc., it looked like a science fiction long time back. But it is no longer a fiction, it is a reality. And the innovations are taking place with a lightning speed. I think yesterday's invention is a history, is redundant. The shelf life of those inventions are very, very short. Now we are talking about what is the role of IPR in this. When you're talking about the role of the IPR, we are talking in terms of patents, trademark, etc. Now, as far as the law is concerned, the law is touching us, all of us, without knowing. Every day, every minute, like ether, law is touching you, but you don't realize it. Only when you are affected, then you know, oh, something is hitting you. When the technology is developing so fast, the law has to keep pace. If the law does not keep pace, then you are applying the existing law to your future inventions or a future technology, which is not very efficient. Now, when it comes to the question of IPR, we are having a big problem, because all our laws are to be done in terms of TRIPS agreement. You cannot go beyond. If you do anything, it can be a violation. So other country can take you to the Geneva and then say, hey, what you are doing is you are not fulfilling your obligations. So therefore, there is a big problem as far as the IPRs are concerned, as I see, that the existing law cannot be amended because there is no renegotiation of the WTO. We have been grappling with the problem called software per se. That per se has given job to so many lawyers. And will continue to give. And you can't change per se. The problem is, that is a negotiated, multilateral negotiated document, unless and until Doha round or other rounds have to necessarily come back and then say, remove per se or remove software. One of the things has to happen. If that happens, then only then we can apply this particular amended law to the new things. If it is not done, then you have to assess the software per se to artificial intelligence. Now, the problem. How do you implement or apply the existing law to your future technology? Because at that time, I am sure, way back in 1995, when the entire negotiation took place in Uruguay, none of them had any intelligence about artificial intelligence. They had intelligence, definitely, natural. We are now talking about artificial intelligence. Now, if they did not have that, then obviously everything which they are talking about, novelty, etc., we are all talking about the tangible objects. There were some intangibles then, but not the intangible we are now talking about. In this scenario, we are now going to interpret the existing law to the new one. It is like putting the square peg in a round hole. And it does not fit. The patent office says, this is how it is fitting. The inventor says, no, this is not the way to fit. Ultimately, who has to go to the court? The lawyers come in, as I told you. And they try to force fit this particular thing. And then Viswanathan was saying, we must have certainty in law. Very easily said. When there is no certainty in technology, he wants certainty in law. How is it possible? It's not possible. So therefore, today, if the IPO or EPO, if they issue a guideline as to what exactly meaning is the per se, will that guideline become a Bible to say to solve all the problem in the future? It cannot be. That is why the courts will say, we will decide on a case-to-case basis. What does it mean? It is not possible to lay down a unified law or a guideline or a judgment which will say, this is the law, you follow it. It is not possible because situations are going to be different. A minor change in the situation can definitely result in different interpretations. And therefore, while artificial intelligence can take place and do all the intelligence as far as the industry is concerned, as far as the lawyering and judgments are concerned, there have to be application of mind. Because if the application of mind doesn't exist, the judgment is wrong. The patent controller, when he gives a judgment without application of mind, it is the first attack, saying that this man has done without application of mind. There you cannot say application of artificial mind. You cannot. So there has to be a physical application of mind on an artificial intelligence. This is where the contradiction comes in. It is a contradiction in terms. Today, when I was in the US, I had a seminar wherein about more than $4 or $5 billion are being invested in creating artificial intelligence in legal drafting. Lawyers here beware. One day, or artificial intelligence may come, they draft the patents, you don't require lawyers. They can draft the memos, you don't require lawyers. They can draft contracts, you don't require lawyers. So therefore, they were asking me, Lakshmikumaran, you are one of the leading lawyer. I'm not saying myself. They said, you are a leading lawyer, so why don't you give us intelligence to create artificial intelligence? I said, no problem. I have no difficulty in giving. I will spend 2 days, 3 days. But is it enough? Now, if we are going to create these types of intelligence by large volume of drafts being made all over the world, imagine, I think India's population of lawyers is more than 1 million, and so also in the case of US. And imagine they are working, say, at least 360 days. I think you will not agree, Mr. Hines will say about 6 days out. So even if you work 300 days or 250 days, imagine the amount of work that is being created, and the artificial intelligence has to collect all this big data and then come back and say, this is the best draft possible, etc. And if that is being done, then obviously you can eliminate the lawyers. So probably eliminate the doctors. Huh? That's what he was saying. You can do in MR, I think, etc. Doctor need not come. Artificial intelligence will answer this question, etc. In which case, the lawyer's fees should come down, doctor's fees should come down, and whose fees will go up? AI's fees will go up. Who has got it? Somebody has got it. Who has got the intelligence? Who has licensed it? He has licensed it. Then will come immediately standard essential patents, whether it should be done or not, and it is a larger interest, compulsory licensing, whatever it is. If the drafting is taken over by AI, the interpretation will still by the lawyers. What I am trying to say is, today we are in a situation where the law needs to be amended to take care of the future inventions, but unfortunately, in the case of IPR, we are stuck with the WTO agreement unless and until there is an effort by all the countries put together to make an amendment. This particular issue of creation of so much of IPRs and application of existing law into the future one is going to be a major task. And lawyers will have a different role to play, even in the case of artificial intelligence. I'll stop here at this time. We'll see later.
Thank you very much, Mr. Lakshmikumaran, for explaining us the role of the lawyers in this picture. Yeah, I switch now to Mr. Grant Philpott, our last presenter, but I would like to ask you also perhaps to answer already on some of the questions which were raised here. Because of the time, I'm not sure whether we can have a second question round, and therefore please take already the questions aboard which we heard already. Please, Grant, you have the floor.
Thank you, Raimund. Gosh, how do I follow that? It's not really possible. Firstly, let me say what a pleasure it is to be here, to see so many familiar faces, and it's a privilege again to support the cooperation between India and the European Patent Office at this event. We've heard a great deal about the fast pace of change and innovation, the so-called truckload of gorillas. I like that Mr. Sanjeev called it so descriptively and graphically earlier on. And we in the patent profession have witnessed the rise and fall of many technologies in recent decades, like biotechnology, nanotechnology, and the plethora of ICT-enabled innovation, that one perhaps gets a little bit skeptical about another development that is claiming to be a step change in our environment. Markets evolve and the patent system adapts accordingly, and we've seen that and we've taken it in our stride. But as we've heard several times already this morning, the technologies belonging to what we in Europe call the fourth industrial revolution are not simply an evolution. They have the potential to be the most disruptive challenge to industry, society, and to the patent system itself that we have ever seen. And the members of the panel have already reinforced that message time and time again, and indeed the earlier talks this morning did so as well. But this is then a truckload of gorillas, and to me and all of us sitting in patent offices, it feels very much as though we're the first stop on the road of that truck speeding towards us. And what are we doing about it? Well, as the world's main provider of patent information, the EPO is uniquely placed to observe the early emergence of technologies of this fourth industrial revolution and to monitor their development closely over time. Indeed, the EPO has its first insight into the evolution of CII in general and 4IR more specifically, and we have been observing carefully how the technologies are driving forward and will transform the entire structure of the world economy. So for several years, we've been watching the proliferation of ICT inventions outside of the traditional homes of computing and telecommunications, audio, video, media. And we have seen how they have spread into areas like medical technology, textiles, manufacturing. And the companies are breaking out of their traditional silos now at a rate of knots and are becoming very much multidisciplinary. And we heard indeed the request that patent offices likewise become capable of being multidisciplinary. The EPO is well placed to deal with that in the first instance because traditionally it has its 3 examiner divisions, and where necessary we always constitute those from different disciplines where the application requires it. But of course we can go further than that, and we will need to recruit specialists with different skill sets which are appropriate to ICT innovation as it develops. But please don't misunderstand me. I'm not suggesting that we need to throw out our established policy on computer-implemented inventions, because that is the bedrock on which we build our patent system. Over several decades at the EPO, we have indeed developed a robust and responsive system with case law evolving to match the changes in technology, and which has been carefully followed by our examiners. And indeed, our main aim, and my main aim in the European Patent Office, is to provide the uniformity and the harmonized approach which we have already heard a call for this morning from Mr. Narayanan on my left of the panel. But of course, we have to adapt to the opportunities and challenges appropriately. So we at the EPO have monitored technological change and adapted to carefully enable the office to accompany these transitions as they occur, and we want to be accompanying with them rather than lagging behind the curve. So over the last 3 years, we have introduced a number of changes in the office to do this, one of which, and I would say foremost, has been an annual adaptation of the CII content of our guidelines so that we review current technology and actually look to see that we're providing the best advice and guidance both to our examiners and likewise to our applicants, so that you can stand the best chance of drafting applications capable of being granted at the European Patent Office. We have also recently decided to reorganize within the operational area of the European Patent Office in order to model the journey on which industry is currently on to follow ICT, and we are currently just finalizing that process to go live on the 1st of January with 3 main new technical sectors, one of which is ICT, one is healthcare, biotechnology and chemistry, and the other one mechatronics and mobility. And in the very words you can hear computer implemented inventions and everything associated with them come to the fore, and the aim indeed is to provide a service which is fit for the modern era. But we want to build this on a really objective analysis of the fourth industrial revolution landscape, and to do that we have carried out a number of evaluations based on our very large documentation set. And we have looked at, for instance, the penetration of computer-implemented inventions in classical areas such as the automotive area, the aeronautical area, and in healthcare. And we see there that over time we have developed up to levels of about 40 to 50% of penetration now of software into these classical areas. And that has very much woken up the European Patent Office to the reality of what is happening. And then we have looked in the past 12 months more narrowly at the subset of fourth industrial revolution technologies, and here connectivity and the use of data and autonomous features comes very much to the fore. And whilst we've developed quite a tight subset of those technologies, we've come up with about 48,000 patent applications, both published and unpublished, by the way. So it's very current, but we do see there a very exponential development in the rate of which these applications are coming in. And we are able to tune our recruiting and our organization appropriately to what is coming our way. So these are really a taste of how the EPO is not aiming to block or to stop that speeding truckload of gorillas, which is coming so fast down the road towards us as the first stop. But we are intending to, in fact, refuel their truck and hand out a load of bananas to them so that they can actually travel even faster on that journey. So there is a lot more behind what we are doing to prepare for this, but we want to accompany industry. We want to be your partner on this journey. Your gain is our gain. We succeed together or we fail together in this big challenge. And the European Patent Office is very much, I believe, up to that challenge and indeed has started in that process very energetically. Thank you.
Thank you very much, Grant. So, lunch has already begun. Lunchtime, at least. Yeah, but nevertheless, I think we should, and we agreed, Mr. Tata and I, we agreed that 2 or 3 questions from the audience, or also if possible from here, should be allowed, because, well, there are perhaps some. Who would like to ask a question to one of our colleagues here? Please, madam. Perhaps you tell your name and from where you are.
Shilpi, and I'm the UK IP attaché. So my question is to Mr. Viswanathan. So you were talking about the online portals where we can just get our access to medicines or maybe doctor's advice, and we don't have to go to the hospitals. So I was actually practicing a month before, and I have actually dealt with these kind of portals, like I have actually advised them. And I just wanted to ask, because in my mind, there is a reliability factor. So when I'm going to the doctor, I understand him, I know him. So how do you, explain that situation where you can say, okay, I know this doctor, he's reliable. There's a personal touch involved.
Absolutely.
And when you're talking about these online portals, we don't even know. And I also want to know if these are being regulated by some kind of, industries or maybe by government or any
Yeah, so I think that's a great question, because ultimately it's the trust, right? You need to trust whatever advice is being given to you. And I don't know if you've heard of the hospital called Mercy Virtual. This is a hospital in the US. If you go to Google, you will find it. It's basically a hospital, a virtual hospital that monitors and provides advice to a lot of hospitals around the US. And they are the ones that sit in the background, monitor the data, and they get all they have. It looks like basically it doesn't look like a hospital, because they wear scrubs, but they're doctors and nurses, but there are no patients, there are no beds. All the beds that they look at are far away. But one of the nurses, and most of them are experienced people, so they have practiced, like you said you did, and then joined this unit. And one of them, in the end, says, there's nothing in the world that can replace me standing by the patient's bedside and saying, hi, I'm Tris, right? The same thing applies from the patient's perspective. There's nothing that can replace for the patient somebody standing there holding his or her hand and saying, you'll be better soon. However much, however big the screen is, it's still 2-dimensional. Even a 3-dimensional image is not going to give you that feeling. So you're right. But at least in our case, we're not talking about portals where you just get advice, right? We are more focusing on the artificial intelligence aspect of it. Once the trust is built up, maybe you will take advice from somebody that is sitting far away, or even from a computer. Today, without knowing it, you do take advice from artificial intelligence. When you go to Amazon.com and you buy something, 10 things pop up. I don't know how many of you have not looked at what is there and said, hey, this looks like something that I think I might be interested in. So there, where the criticality of it is low, you do take advice already. It's just a matter of time, maybe in the next 100 years. I don't know. I'm not going to predict that. But at some point in the future, you will trust what is being given to you. I don't know how many of you know of the website called WebMD. There are many, many people who go there and put in their symptoms and kind of get an idea of what the disease might be. Now, if you say cough, it'll be anywhere from cough to cancer, right? So you don't know what the problem is. But the more, and that's where your artificial intelligence can help you, because if you say cough, think of it more from an Ayurvedic doctor's perspective. If you say, I have a cough, he's not going to give you medicine. He or she is going to ask you your symptoms, your history, and so on. What he or she probably doesn't have is a genomic makeup. But a lot of times, they ask you for a lot of the contextual parameters, and then they look at your eyes and your, whatever. So those are the vital signs. They take all of this together and then declare, maybe you have something that could be ABC, narrow it down a bit further, and then they identify what the problem is. Artificial intelligence can help you do that. So yes, you're right, trust is important. It'll take time, but once it's built up, I think it'll happen.
So I just asked this also, is there any
Thank you.
regulatory authority to...
Yes, well, I don't know if there's a regulatory authority for this particular, kind of advice. I think the FDA will definitely be there. So the usual regulatory authorities will be there. So for instance, Philips has the digital pathology solution, which is the first FDA-approved digital pathology solution in the world. There, they do take images, and give some kind of advice to the physician as to what a particular lesion is, for instance. But yes, you will need to go through the usual regulatory process. It is, in the end, a medical device.
In fact, the trust factor applies also to lawyers.
We left a bit the field of IPRs.